Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to continue my discussion of Bill C-21 by looking at the emergency prohibition order sections. These are what the government has been calling the red flag laws. Now, there's actually already provisions that are already in the criminal code that allow for taking guns away from somebody who is sort of an immediate danger. One method allows for the police to go and get a warrant, which they can do like by fax, where they can show essentially that somebody is a danger to themselves or others. And that warrant allows for the police to go and seize firearms and start a procedure there. The other method is if the police have enough grounds that they could get a warrant, but just because of the timing, that this is such an imminent danger, they can't go and do it. There's actually provisions that allow for this to happen, where they just go in and take the guns and then essentially provide the information that would have been used for the warrant after the fact, as well as the information that shows why they couldn't wait for a warrant. Even though a warrant is pretty fast, I mean, they can have that turned around in maybe a couple of hours. So now, once that happens, once they go in and seize all the firearms, that cancels any firearms license you have until an eventual hearing. And at that hearing, the court can decide either that that was, improper, that they shouldn't have taken your guns, that, you get them back, in which case your license is reinstated, or the court can decide that your firearms are forfeited, that you lose them, and that you get a firearm prohibition. But the prohibition doesn't kick in until after you've had a chance to appear yourself in front of the court to explain why you should or should not be given a firearms prohibition. So you get that chance to defend yourself before the firearm prohibition kicks in. And this is extremely important for reasons I'll get to, but it's not something that we find in this current law. So let's dive into the law now and have a look at how this law works, this proposed law, and I can talk about how this is different and how it may affect people. So we see application for emergency prohibition order. Any person may make an ex parte application to a provincial court judge for an order prohibiting another person from possessing any firearm, crossbow, prohibited weapon, prohibited device, prohibited ammunition, or explosive substance, or all such things if the person believes on reasonable grounds that it is not desirable in the interest of the safety of the person against whom the order is sought, or of any other person against whom the order is sought, should possess any such thing. Now, both the current provisions and this new proposed provision are ex parte applications. But right now, only the police can bring it. And that's kind of important because what ex parte means is that it's without notice. The person against whom the application is being brought doesn't get told in advance that this is happening and doesn't get to be there to present their side initially. So now whenever there's an ex parte application, there's a duty of fairness. They're required to present both sides. So if the police have some information that's in their possession that suggests maybe that you're not a danger, they're required to actually present that as well. Like if they talk to 3 people and 2 of them say that you're a real menace and the third person says, nah, he's not a menace, those other 2 people just have a grudge against him. The police actually would be required to provide that information from all 3 people. They have to sort of give full fairness to the court. Now that same requirement would apply here, except here it's any person. So this is just random members of the public can bring these against random other people who they may have no direct connection to. And these people aren't necessarily going to understand that duty of fairness. What I expect we'll see here is much more slanted presentations, where they present only the things that suggest that you're a bad person and not the other details. So this creates a real possibility for abuse. We do see, ex parte restraining orders in, for instance, the domestic violence context, but here in Alberta, at least, you have to have some connection directly to the person. You can't just bring this against somebody, some random person who you don't like. So this is extremely problematic when it's just any person can bring this. I say this because I did a video not too long ago where I noted how somebody saw one of my videos, completely misinterpreted it. They admitted to me later that they hadn't actually watched much of the video. They watched about the first 10 seconds and then leapt to conclusions. And, then they got upset enough that they were sending me death threats. That same person instead could go through this prohibition order thing and say, I have this mistaken impression of Mr. Runkle, and please take his guns away. And the court might grant it if they've only heard that one-sided skewed thing. Now here it works a little differently. If at the conclusion of the hearing, the provincial court judge is satisfied that, it's not desirable in the interest of the safety of the person or any other person that you have those things, they will make an order prohibiting you from having firearms, crossbows, prohibited weapons, restricted weapons, prohibited devices, which of course would include any airsoft stuff that you've still got, ammunition, prohibited ammunition, etc., 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 for a period not exceeding 30 days, beginning immediately. Now, when they say not exceeding 30 days, I'm going to imagine that just all of these will just be for 30 days, or at least until the next hearing. So now that firearm prohibition is something that none of the current provisions impose immediately. What they do instead is they take your license away, and that distinction is going to be very important for particular groups within Canadian society, and those people are especially military officials or military, soldiers or police. This law actually has the greatest effect against police officers and the military. So if you're thinking of who you want to target, are police and military the people? Maybe not, maybe. So that order will be served on you, and it'll probably be served at the same time as they come and kick down your door to take your stuff, because the provincial court judge can either issue a warrant for them to seize your firearms, weapons, etc., if they believe that you have any of those things. Of course, that's going to be likely the case if somebody is going in and saying you need a prohibition order. And if the judge doesn't issue that order, a peace officer can actually go and search and seize anyway if they believe that it's required to do so immediately without getting a warrant. And I suspect they're going to think that because they're going to have a court order in hand that says that you're a dangerous person who needs to be banned from having guns. So why wouldn't they go in immediately? After they go in and search and seize, they have to present to the court what they took and potentially why. Now, at this point, they will fix a date for a hearing for when you go and appear before the court to argue your side. This will be the first time you get to present your side of the story. However, this happens after they've already put the firearm prohibition. And at that hearing, they can either ban you from having guns, thereafter, or they can return your firearms. And if they don't set a hearing date before for that 30 days, then you get your stuff back. But you will have been banned from having firearms and, a prohibition from having firearms right at the outset. So normally, if you have your stuff seized and you're just your firearms license is canceled, you can potentially still use firearms in certain circumstances. One that comes up is if you're under the direct and immediate supervision of somebody who still has a firearms license. So this happens at certain ranges, or if you go out with your friends at the range, and you'd have to be under their direct and immediate supervision the entire time you're using firearms, which kind of suggests you're not going to be a serious risk. But the other group that this really is going to affect is police officers, because, a police officer who who doesn't have a firearms license or who loses it can still go and be a police officer on duty and, carry their firearm, or courthouse sheriffs, or, so forth. And I know there are some police and some other, people who carry firearms because they work for the government and that is, how they function. Soldiers as well. But if you're under one of these firearm prohibitions, then you can't carry a firearm, even if it's on duty. You would not be able, the firearm prohibition overrides your police officer status, your military status. And so even though you might be a soldier or a police officer, if somebody hits you with one of these things, you cannot carry a firearm. So that's going to be, or should be, extremely worrying for police, because let's say somebody has a grudge against you. Police officers who are watching this, tell me, have you ever had anyone have a grudge against you? Anyone ever filed a complaint that wasn't justified? Does this ever happen to you? I'm thinking maybe it does from time to time. So if somebody files an unjustified complaint, let's say that they go in and say, I was walking down the street and Joe Smith, for no reason, jumped me and started punching me, and look at this big black eye I've got. And the provincial court judge hears all that and says, look, he's got a big black eye. He says he knows the person who attacked him, and that it was for no reason. So yeah, I'm going to issue this firearm prohibition order. Well, later what it turns out is that Joe Smith is actually Constable Joe Smith. And, the reason why he went after this person is that that person had several warrants out for their arrest and has a lengthy criminal record, including violence. And in fact, threw the first punch and, several punches thereafter before the officer sort of responded with force. But again, ex parte, the officer's not going to be there to present his side, and the judge isn't going to be able to look up any of the people involved. They're not going to have access to, any of the computer databases. So police officer gets a firearms prohibition and can't go to his job the next day. That seems like a bit of a problem to me. Normally, these things have to go through the filter of the police. And while I'm not a super huge proponent of the police, generally speaking, there are some good reasons for that. The police can do some investigation before the fact to determine if the complaint is justified. The police can do things like run everybody's name. And, for instance, they could see, oh, you're wanting a firearm ban against your ex-wife. And as it turns out, you have been accused, you, the person asking for this ban, have been accused of several assaults against her, as well as criminal harassment, stalking, all sorts of, you are an angry, abusive guy towards your ex-wife, and you are now asking us to go take her guns. We're not going to do that. Do you think that if that guy goes before a provincial court judge because he wants to take his ex-wife's guns away because he's abusing her and wants to, continue doing so, or wants to just use the court system as a weapon, do you think he's going to say, yeah, I've got 6 sets of outstanding assaults against her that are currently before the court? Do you think he's going to say, yeah, I'm totally stalking her, I'm totally harassing her, she's actually the victim in this? I don't think he's going to present that. So this provides a weapon for anyone who might want to use the court system to execute a grudge against, exes, against, coworkers they don't like, against neighbors they don't like, against somebody who annoys them on Twitter, against somebody who, whatever the circumstance. So that's why I've been sort of calling this a swatting provision, because it allows for somebody to go before the court and give a one-sided version of things that results in police showing up, kicking down their door. And these searches are never nice. You should expect that if they're doing one of these searches, that you're going to end up on your front lawn, face down in the grass, with a rifle pointed at the back of your head, really hoping that that officer has good trigger discipline and doesn't have the hiccups. So, I've seen video, I've heard audio from people who are in the middle of one of these searches, and often they're in fear of their life. They're in fear for their safety when this is happening. So these are not something that just is something to be brushed aside lightly. These will be extremely traumatic events for the people subjected to them. Now, it goes even a step further because there's another emergency provision here that is potentially even scarier, because you don't have to have done anything or even ticked anyone off to maybe be subject to one of these. So let's have a look at that. So, emergency limitations on access order. Any person may make an ex parte application to a provincial court judge for an order under this section if the person believes on reasonable grounds that A, the person against whom the order sought cohabits with or is an associate of another person who is prohibited by any order made under this act or any other act of Parliament from possessing any firearm, crossbow, prohibited weapon, restricted weapon, prohibited device, prohibited ammunition, or explosive substance, or all such things, and the other person would or might have access to any such thing that is in the possession of the person against whom the order is sought. So what this means is you don't have to have done anything. You just have to cohabit with or be an associate of. That's a really broad term. Somebody who has a prohibition. You might not even know they have a prohibition, but they think, your friend got a prohibition order, and now they think that because you've been longtime friends, that you might give him a gun. And so they're going to kick down your door to take your guns. There is currently a provision that allows for this kind of order where they take your guns because of this. But these orders, the ones that exist now, can only happen with court, with notice and with you having a chance to present things, which to my mind is appropriate because this is a situation where they're not saying that you are a danger. They're saying that, somebody else has done a bad thing and they want to take your guns because they're concerned about your relationship with that person. Well, you're allowed to associate with bad people. You are allowed to have friends. You are allowed to live with other people. You just have to make sure that they can't have access to your firearms. But, this provision basically says you don't even have to have done anything yourself. They can go after you for who you know. And again, kick down your door, potentially, drag you out onto the front lawn, point a rifle at the back of your head while they toss your house. So these are extremely worrying provisions. I think that these are provisions that go beyond just being a threat to gun owners, but also are a threat to sort of ordinary members of the public who might have somebody who has a grudge against them. But more than that, the only place where this really provides sort of any sort of additional protection over the existing rules, where it really, where that prohibition really matters, is if you really want to make sure that this prevents a police officer from going into work the next day. If I was trying to build this bill to target police officers specifically, I couldn't do a better job. I mean, my reading of this, it's in this sort of uncanny valley between incompetence and malice, where it's really hard to tell what they're doing here. But I would say that this is an anti-police officer bill. If I was a police officer, I would be terrified of this. If I was a court sheriff, this bill is right aimed at me, if that's, who I am. Or if you're in the military, again, can you imagine you're set to deploy and, you're deploying tomorrow and somebody serves you this saying you're banned from having firearms? Is that going to mess you up? Oh, you betcha it's going to mess you up. So anyway, this is a really nasty provision. As noted, I've been sort of describing it as a swatting provision. I'm sure it's going to be sort of sold as though this is some kind of protection for women. But quite frankly, I think that we've already seen situations where women have had false complaints made by abusive ex-spouses or ex-boyfriends. But this is going to amp it up to 11 because we're just cutting out the middleman. They can go directly to the court. The other thing is, if you're thinking that this is a protection for somebody who is in danger and who immediately needs help, somebody who's just like, I need help right now, this is actually a worse provision than the ones that already exist, because this has to go before a provincial court judge. The police can get a warrant any hour of the day, any day of the week, whenever it needs to happen. So, if this is 3 a.m. on a Sunday, they can do it. Like, that's no problem. So 24/7, the police are able to respond to this. Provincial court judge, on the other hand, they're there 9 to whenever court closes, which might be 4 o'clock or it might be whatever other time. 5 days a week. If you're in a major city, if you are in a more remote jurisdiction, they might sit maybe twice a month. So, you are in super danger. Wait until the 2nd or 4th Thursday of the month. That doesn't seem like a really great provision. So, immediate danger as soon as you can book it in. And, it's not clear sort of, I suspect the courts will allow people to just walk in and do these rather than requiring you to schedule them. But still, lots of courthouses don't sit every day of the week. And certainly none of them sit Saturday or Sunday or 3 a.m. So I don't see the benefit here. I see this as, a showpiece, but a showpiece that really is ripe for abuse. And as noted, ripe for abuse, especially against police officers and the military. So thank you for watching. Please like this video. Please share it with your friends, especially if they are police or the military, because they should be scared of this. I'm scared for them. And, I'm a criminal defense lawyer. I'm not normally sort of super huggy with the police, but I also think the police should not be subject to unfair and unjust processes, and that's what this is. So, why are you making me stand up for the police, Liberal Party? Come on. I mean, I don't want to be unfair to anybody here. This is so bad. Anyway, thank you for watching. Please like, please share with your friends. Please subscribe to see more content. I also want to thank my Patreon supporters at the $50 level, Demo, Sir Daniel Wicks of Alberta, Canada's National Firearms Association, North Central Process Service, and Kyle Martin. At the $20 level, Cameron Johnson, Dale Nesbitt, Andrew Elsich, and Sights and Arms Limited, as well as a number of you at the $10 level who will be in the crawl immediately following. I wish there was more good in this bill that I could, I will be talking at some points about the couple of things that I agree with in the bill, but the stuff that is bad is just so bad and so shockingly bad, and there's just so much of it. Anyway, thank you for watching. I hope this has armed you with knowledge.